global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, beautiful people. Welcome to Global Happiness Today YouTube channel. Finally, this is breaking. This is exciting. This is good news for those supporting Nnamdi Kanu and lovers of freedom, IPOB in general. United Nations have finally intervened. In fact, they are insisting Nnamdi Kanu must be set free. They have indicted the Nigerian government, giving a lot of details what must be paid, compensation that must be paid to Nnamdi Kanu, and when and how they must release him. In fact, this is super exciting. Let's go fully into the details to find out what United Nations UN Human Rights have decided to do against both Nigeria and Kenya, and what Nnamdi Kanu stands to gain. In fact, his release is around the corner. I must say congratulations ahead, but let's go straight into the news. The United Nations UN Human Rights Council Working Group on arbitrary detention has indicted both Nigeria and Kenyan government for the arrest and extraordinary rendition, torture and continued detention of the leader of the indigenous people of Biafra IPOB, Nnamdi Kanu, without due process. United Nations therefore asked Nigerian government to immediately release Kanu unconditionally and pay him adequate compensation for arbitrary violation of his fundamental human rights. It also recommended that government officials responsible for the torture meted to indigenous people of Biafran leader to be investigated and punished. United Nations body further directed Nigeria to report back within 6 months of the transmission of its opinions on Kanu's matter, steps taken to comply with all the recommendations thereof. It referred the case of Kanu's torture to Special Rapporteur on Torture and other cruel, inhumane and degrading treatment or punishment for further consideration. The United Nations Working Group also threatened to take further action to ensure the recommendations are complied with, noting that both Nigeria and Kenya are signatories to the convention and should comply, and they should comply. The 16-page report dated July 20th, 2022 was adopted on April 4th by the Working Group on Arbitrary Detention at its 93rd session held between March 30th and April 8, 2022. The unedited version of the document cited was marked Opinion Number 25/2022 concerning Mr. Nnamdi Kene Oku Kanu. Wow, that's his full name. I take that again. Mr. Nnamdi Kene Oku Kanu, Nigeria and Kenya. The working group on arbitrary detention was established in resolution in 1991/42 of the United Nations Commission on Human Rights. In accordance with this method of work, the working group on December 30, 2021 transmitted to Nigeria and Kenyan government a communication concerning Mr. Nnamdi Kene Oku Kanu. According to the report, Nigeria replied to the communication on 25th January 2022, while government of Kenya did not reply. Both countries are parties to the International Covenant on Civil and Political Rights. The working group said in the report that Kanu was a victim of state persecution as Nigeria failed to provide convincing explanations with proof that he is guilty of treason and other criminal allegations leveled against him. Noting the failure of the government to explain what actions of Mr. Kanu amounted to such criminal acts and how, and observing the lack of any evidence that any of his actions may in fact amount to such crimes, the working group concludes that Mr. Kanu is in fact being persecuted for peaceful exercise of his right, most notably his freedom of opinion and expression. In the present case, the government of Nigeria has presented no exceptions permitted under Article 19, subsection 3 of the Covenant, nor is there any evidence to suggest that Mr. Kanu's exercise of his right to freedom of opinion and expression was anything but peaceful. In fact, the government has chosen not to provide any explanation for the arrest, detention, and subsequent proceedings against Mr. Kanu. In these circumstances, the working group concludes that Mr. Kanu's detention is thus arbitrary under Category 2, United Nations Working Group said. The working group also said there was no evidence that international laws were observed in the arrest and rendition of Kanu from Kenya. The 16-page dossier read in part, and I quote, "In the present case, Mr. Kanu was not furnished with an arrest warrant by Nigerian authorities, nor was he promptly informed of the grounds for his arrest in Nigeria. Consequently, the working group finds that Mr. Kanu's continued deprivation of liberty violates his right under Articles 3 and 9 of the Universal Declaration of Human Rights, Article 9 of the Covenant, and Principles 2, 4, and 10 of the Body of Principles, and constitutes arbitrary detention under Category 1. Turning to the uncontested allegations that following his rendition to Nigeria, Mr. Kanu remained in pre-trial detention, with his trial having been scheduled to commence in January 2022, the working group recalls that it is well-established norm of international law that pre-trial detention should be the exception rather than the rule, and should be ordered for the shortest time possible. But differently, liberty is recognized under Article 9, subsection 3 of the Covenant as the core consideration, with detention merely as an exception. Therefore, detention pending trial must be based on an individualistic determination that it is reasonable and necessary for such purposes as to prevent flight, interference with evidence, or the recurrence of crime. Such determination was not carried out in the present case, in violation of Mr. Kanu's right under Article 9, subsection 3 of the Covenant. Further, in accordance with Article 9, subsection 3 of the Covenant, an arrested person is to be brought before a judge within 48 hours. 27. This was not satisfied in the case of Mr. Kanu, and the working group therefore finds a violation of Article 3 and 9 of the Universal Declaration of Human Rights, Article 9, subsection 3 of the Covenant, and Principles 11, 37, and 38 of the Body of Principles. Furthermore, in order to establish that the detention is indeed legal, anyone detained has the right to challenge the legality of his or her detention before a court, as guaranteed by Article 9, subsection 4 of the Covenant. The working group wishes to recall that according to UN Basic Principles and Guidelines on Remedies and Procedures of Rights of anyone deprived of their liberty to bring proceedings before a court, the right to challenge the lawfulness of detention before a court is a self-standing human right, which is essential to preserve legality in a democratic society. This right, which is in fact a preemptory norm of international law, applies to all forms of the deprivation of liberty. 29. To all situations of deprivation of liberty, including not only to detention for purposes of criminal proceedings, but also to situation of detention under administrative and other fields of law, including military detention, security detention, detention under counter-terrorism measures. Moreover, it also applies irrespective of the place of detention or legal terminology used in legislation. Any form of deprivation of liberty on any ground must be subject to effective oversight and control by the judiciary. This was also denied to Mr. Kanu, thus violating his right under Article 9, subsection 4 of the Covenant. Finally, turning to Mr. Kanu's pre-trial detention in Nigeria, the working group recalls that according to international human rights law, in particular Article 9, subsection 3 of the Covenant, any person detained while awaiting trial is entitled to trial within a reasonable time, or otherwise shall be released. Article 14, subsection 3 and subsection C of the Covenant also guarantees the right of anyone charged with a criminal offense to be tried without undue delay. In the absence of a substantive response from the government of Nigeria, the working group finds no legitimate grounds for the delays in trials against Mr. Kanu. Consequently, the working group finds that the government of Nigeria failed to establish a legal basis for detention of Mr. Kanu. His detention is thus arbitrary under Category 1. The UN working group said that both the Nigerian government and the Kenyan government should take responsibility for Kanu's right violations. The working group wishes once again to underscore the collusions between the governments of Kenya and Nigeria in the rendition of Mr. Kanu and reiterates that both governments bear joint responsibility for any violations Mr. Kanu's right in Kenya and Nigeria. The working group has already established in its discussion of the detention of Mr. Kanu in Kenya that he was arrested and detained due to peaceful existence or peaceful exercise of his right. The working group notes that the sources has argued that same in relation to Mr. Kanu's arrest, detention and trial proceedings in Nigeria. Notably, the government of Nigeria has chosen not to address the substance of these allegations. The working group notes that it is not contested that Mr. Kanu is accused of the crime of conspiracy to commit a treasonable felony through an agreement with others to be broadcast from London in view of the establishment of Biafran sovereignty. The sources noted that while treason consists of leveling war against Nigeria under Nigerian law, the federal government of Nigeria does not allege any action implicating Mr. Kanu in the contemplating planning or incitement of war against Nigeria. The source argues that Mr. Kanu was in fact advocating for a peaceful referendum for the establishment of a Biafran sovereignty in conformity with international and other relevant laws. The working group recalls that the freedom of opinion and expression as expressed in Article 19 of the Covenant is an indispensable condition for the full development of a person. It is essential for any society and constitutes the foundation stone for every free and democratic society. It also recalls that the freedom of expression receive and impart information and ideas of all kinds, regardless of frontiers, and that this right includes the expression and receipt of communication of every form of idea and opinion capable of transmission to others, including political opinion. Similarly, in Resolution 12/16, the Human Rights Council called on states to refrain from imposing restrictions which are not consistent with Article 19, subsection 3, including the discussion of government policies, political debate, reporting on human rights, engaging in peaceful demonstrations or political activities including for peace or democracy, and expression of opinion and dissent, religion or belief. The United Nations Working Group further said that the Nigerian government could not disapprove claims by Kanu that he was denied effective legal representation, including access to his United States lawyer. The source has submitted, and the government did not address that Mr. Kanu was denied effective legal representation. The working group considers legal representation as being a core facet of rights to a fair trial. Legal assistance should be available at all stages of criminal proceedings, namely pre-trial, trial, and appellant stages to ensure compliance with fair trial guarantees. Any denial of access to lawyers substantially undermines and compromises an accused individual's capacity to defend himself or herself in any judicial proceedings. As the working group has stated in Principle 9 and Guideline 8 of its basic principles, persons deprived of their liberty have the right to legal assistance by counsel of their choice at any time during the detention, including immediately after the moment of apprehension, and must be promptly informed of this right upon apprehension. Access to legal counsel should not be unlawfully or unreasonably restricted. Article 14, subsection 3 and B, subsection B of the Covenant entitles defendants to adequate time and facilities for the preparation of their defense and to communicate with counsel of their own choosing. Defendant must have access to documents and other evidence, including all materials that the prosecution plans to offer in court against the accused and that could assist the defense. Recalling General Comment number 32, a detainee has the right to have prompt access to legal counsel, meaning that a lawyer must be able to have private communications and meetings with the detainee and be able to attend to all investigation without interference or restrictions. A detainee also ought to have access to effective counsel. All of this was denied to Mr. Kanu in working group's view by failing to allow Mr. Kanu to be represented by lawyers of his choice, including an international counsel. The government denied Mr. Kanu's legal assistance at all times, which is inherent in the right to liberty and security of the the person, as well as the right to fair and public hearing by a competent, independent, and impartial tribunal established by law in accordance with Articles 3, 9, 10, and 11, subsection 1 of the Universal Declaration of Human Rights, Article 14 of the Covenant, Articles 37b and subsection D, and 14 subsection T, subsection 2, subsection B2, and principles 15, 17, and 18 of the body of principles, and principles 1, 5, 7, 8, 21, and 22 of the basic principles on the roles of the lawyers. The working group is also disturbed by the source report of the treatment of Mr. Kanu's lawyers and recalls that jurisprudence highlighting that such treatment of lawyers is entirely unacceptable and violates Articles 10 and 11 of the Universal Declaration of Human Rights, as well as Article 14, subsection 3b of the Covenant 41. It is a legal and positive duty of the state to protect everyone on its territory or under its jurisdiction against any human rights violation and to provide remedy whenever a violation still occurs. The working group also considers that Mr. Kanu's presumption of innocence was violated as the department surrounded the court complex with an array of armed forces, creating an atmosphere of intimidation and danger, a submission which the government has chosen not to contest. The working group recalls that the defendant should not be presented to the court in a manner indicating that they may be dangerous criminals, as this also undermines the presumption of innocence. The working group finds a breach of Article 14, subsection 2 of the Covenant. Further, according to the source and uncontested by the government following the rendition to Nigeria, Mr. Kanu was detained in solitary confinement within the headquarters of the department in Abuja, Nigeria. He is reportedly currently still held in a very small cell where he is exposed to daily psychological and mental torture without access to other inmates or any other person except for the department officials. Mr. Kanu is also allegedly denied access to reading or writing materials, and this has been refused access to professional medical care despite a serious heart ailment. The source reports that Mr. Kanu's life is in jeopardy and that he suffers from medical condition are cautioned by gradual depletion of potassium in his system, which has defied any medical solution given to him within department facilities. The working group is seriously concerned about treatment to which Mr. Kanu has been subjected, especially noting its finding that Mr. Kanu was subjected to extraordinary rendition as well as his treatment prior to that. The working group considers it unlikely that Mr. Kanu would have been able to effectively assist with and participate in his own defense during the proceedings against him, and that such treatment proceedings against him rendering him inherently unfair, unjust, in violation of Article 14 of the Covenant for all reasons above. The working group finds that the fair trial rights and procedures guarantees of Mr. Kanu under Universal Declaration of Human Rights and Covenant and other relevant human rights standards were not observed, and that such violations are of such gravity as to render Mr. Kanu's detention arbitrary under Category 3. The UN Working Group said Nigeria also failed to disapprove that Kanu was a victim of political persecution. Mr. Kanu is an activist and the leader of the organization Indigenous People of Biafra, which he founded in 2012. The source alleged that the government of Nigeria is targeting Mr. Kanu due to his political expression, in particular due to his membership in a group politically opposed to Nigerian government. On the question of Biafra, his widely published criticism of government and his work with the advocacy for the indigenous people of Biafra, the government has chosen not to address this allegation. The working group finds that Mr. Kanu has indeed been targeted by the government as a human rights defender on account of his freedom of opinion and expression, as well as his position regarding the sovereignty of Biafra. Mr. Kanu has been targeted on account of his activism in galvanizing momentum for the referendum on the sovereignty of Biafra. The working group considers that his detention violates Article 2 and 7 of the Universal Declaration of Human Rights and Articles 2, subsection 1 and 26 of the Covenant, and is arbitrary under Category 5. Concluding remarks, the working group wishes to record its very serious concern for the well-being of Mr. Kanu, who, according to the source and uncontested by the government of Nigeria, remains in solitary confinement since his arbitrary detention in Nigeria on 29th June 2021. He has been denied medical treatment and medication for his heart condition. The working group recalls that prolonged solitary confinement in excess of 15 conservative days is prohibited under Rules 43 subsection 1b and 44 of the Mandela Rules. The working group is also obliged to remind the government of Nigeria that in accordance with Article 10 of the Covenant, all persons deprived of their liberty must be treated with humanity and with respect to inherent dignity of the human person, and that denial of the medical assistance constitutes a violation of the Nelson Mandela Rules 24, 25, 27, and 30 in particular. According to the source, throughout Mr. Kanu's detention in Kenya and transfer to Nigeria, no family members knew about his location or could access him. Mr. Kanu was not permitted to contact his family during his detention. These allegations have not been contested by either the government. The working group stresses that under international human rights law, all detained and imprisoned individuals have the right to communicate and be visited by their families. The right to receive visits applies to all detainees regardless of the offense which they are subjected or suspected to have been accused under Principles 19 of the Body of Principles. This right could be subject only to conditions and restrictions that are appropriate to legitimate aim. Neither government have argued that the restriction placed on Mr. Kanu's contact with his family confirmed with this requirement. The working group recalls that the Human Rights Council has encouraged all states to cooperate with the working group and has requested them to take account of these views and, where necessary, take appropriate steps to remedy the situation of persons arbitrarily deprived of their liberty and to inform the working group of the steps they have taken. Well, according to Kanu's family, he said this is victory for all freedom fighters. Meanwhile, the Kanu family has expressed delight over the UN recommendation describing the report as victory for freedom fighters. Kanu's younger brother, Prince Emmanuel Kanu, who conveyed the position of the family in an exclusive interview, said that Nigeria must comply with UN recommendations. Inasmuch as they are lawless, they must obey. After now, they must still face the music because internationally they must be held accountable. Now, this was the verdict they finally gave. So, however, the working group reserves the right to take its own action in follow-up to the opinion of new concerns in relation to the case that are brought to its attention. Such action would enable the working group to inform the Human Rights Council of progress made in implementing its recommendation, as well as any failure to take action. Wow. Well, it's a long read. Let's put in a